Hello, and welcome to Bite Size Legal, where we tackle legal issues one bite at a time. My name is Drew Jenkins, and I'm an attorney licensed in Georgia and Alabama. And today we are briefly discussing trust deeds, fact or fiction. As it relates to Georgia and Alabama, I say fiction. Here is why. There are only three kinds of deeds, which we have spoken about before on this program. The seller is either giving a full warranty to the buyer. The seller is either giving something less than a full warranty, such as a limited warranty or a special warranty, or the seller is giving no warranty at all, called a quitclaim deed. So a trust deed then must be one of those three kinds of deeds. The only difference is that the grantee of the deed is going to be a trust. So the seller is not granting the property directly to the beneficiary, but instead they are granting the property to a third-party intermediary, the trustee, who holds the property for the benefit of an undisclosed beneficiary. And this is where we come in. I have clients that will call and they have attended a seminar, they've read a book, they've looked online, or they have a friend who puts all their property into trust deeds. And the reason is it provides asset protection and it provides anonymity. The client is able to control their properties without their name ever appearing of record. Instead, it is the trustee's name that signs off on all the deeds. And in answer to this, I say, so what? Right? In the states of Georgia and Alabama, there is no legal requirement that the members of an LLC be disclosed, which means you can form a company, be the sole member of the company, and then assign either a manager or an authorized signer to sign all documents on behalf of the company. This achieves the same purpose. When someone looks in the record, they don't find your name or the client's name. Instead, they find the name of the authorized signer who's signing as the authorized signer, manager, president, CEO, whatever name that you would like to give the person who signs on behalf of the entity. And you still achieved your objective of asset protection because you have limited liability. So the reason then is, well, why do people have trust deeds? And in some states, those are a viable option. Not every state allows the ownership of an LLC to be private, at least to my knowledge, but Georgia and Alabama do. The question then becomes, well, what is the trade-off between using a trust to manage all of your property or to manage your business or using an LLC? And the answer to that is fairly simple. Trust exists for the purpose of estate planning and asset protection. If you need property that you cannot or do not wish to give to the ultimate recipient today due to some fear of creditors seizing it or waste, or you just don't think they're able to handle it, and you need some trusted third party to handle on their behalf, that's a good reason to set up a trust. If you want to place your personal home into a qualified personal residence trust or some similar mechanism, that's fine as well. But if you want to operate a business, just use a business entity to run it. You don't need to go through the trouble of setting up a trust to run your business. Because then you still have the issue of, well, what are the terms of the trust, right? What rights does the beneficiary have to the principal? Typically, people don't know. Well, what rights does the grantor of the principal in the trust have to retake that principal back out of the trust? They don't typically know. Well, what rights does the trustee have to sell or to encumber with a mortgage the property held in trust? Well, again, they don't know. So instead of forming a company, which is designed to run business, right, operate profit enterprises, which can be done for less than $300 in the states that I am familiar with, instead they are creating some sort of unwritten, undisclosed trust with unknown terms. And forming trusts tend to be significantly more expensive than forming a company. And the reason is because trusts are generally formed in lieu of putting things in a will. They're more complicated than a will, and for the property held in the trust, you actually get to avoid probate entirely. So part of the cost that a probate attorney would charge is being captured in the drafting of the trust itself. So companies are easier to operate for business purposes than trusts are, because that's essentially what they're designed for. The taxes are also going to be different, what forms are filed by the accountant. So for Georgia and Alabama, if someone comes in and says, hey, I need things put in a trust deed, The question is, well, why? And the answer has almost always been, in my experience, I'm looking for asset protection and some privacy. Well, in that case, you're in luck. We can set you up with a limited liability company and go forward from there. So this is a little bit of a shorter one. This came up this week, in fact, and just wanted to make all of you aware that when you are looking online, things that are useful in other states are not necessarily useful in the state in which you live, which is why it's important to seek counsel who are familiar with the laws in a particular jurisdiction. And trust deeds, so far as they may exist in other states, probably not the best option here. I say probably because there are situations where it may be an appropriate use, is to put property into the name of a trust directly, but it's not typically going to be for running a business. So if you have any additional questions or comments, I invite you to leave them below if you're watching on YouTube. If you are watching this on WeChat, just go ahead and respond directly in the thread. And for the rest of you, feel free to send me an email, and we will see you next week. Thank you.